One federal judge just pulled off something that absolutely nobody in the nation's capital anticipated. He didn't modify a statute. He didn't alter a charge. He examined the entire licensing framework that American citizens have operated under for generations and ruled the whole apparatus unconstitutional. And what unfolded afterward is about to transform everything you believed you understood about your freedoms. Here's what makes this story extraordinary. This didn't begin with the Supreme Court. It didn't start with some high-profile politician chasing headlines. It began with a single federal judge presiding in a courtroom most Americans have never even heard mentioned. He examined a licensing system everyone assumed was untouchable, and he declared it incompatible with the Constitution. Most judges take cautious paths. They trim a provision here, adjust a fee there, make small changes that preserve the status quo. This judge went straight for the foundation. He ruled that the very idea of asking the government for permission to exercise a constitutionally protected right is fundamentally unconstitutional. That one decision tells you everything about how broken the system looked from his perspective. But here's what should alarm you. Government officials are already planning their response, and what they're preparing is something most people are not ready for. So stay with me, because we're breaking down exactly what the collapse of the licensing system means, and the quiet replacement strategy states are preparing to roll out the moment they think no one is watching. Let's go back to the exact moment the ruling was signed. This decision didn't target one narrow rule. It didn't focus on a waiting period or a single requirement. It shut down the entire licensing structure in one sweeping move. The moment it became public, the country split in half. Some courts looked at the reasoning and said this is exactly what the Constitution demands. Others went into full panic mode, arguing the judge had gone too far and endangered public safety. Overnight, your freedoms stopped depending on the Constitution and started depending on your zip code. From the Supreme Court's perspective, that kind of chaos can't be ignored. One judge didn't just create a disagreement. He triggered a national emergency that raced toward the highest court faster than anyone expected. But to understand why he ruled this way, you have to look at what he found when he dug into history. He wasn't chasing attention. He wasn't trying to provoke outrage. He was answering a basic question that almost no one had seriously examined in decades. Did early Americans need government permission to carry a firearm? The answer was so clear that even critics struggled to deny it. The Supreme Court soon followed with its most consequential Second Amendment decision in more than 10 years. The ruling made it clear firearms regulations must be consistent with the historical traditions of the United States. And historically, there were no licenses, no permits, no approval boards, no bureaucrat deciding whether you were worthy of self-defense. Firearms were treated like tools, property, and personal possessions, not privileges. That reality made a lot of people uncomfortable, because when the judge traced the timeline into the early 1900s, he found where licensing actually came from. And it wasn't public safety. It wasn't crime waves. It was control. Southern states used discretionary licensing to keep newly freed Black Americans from defending themselves against violent groups. Northern cities used the same laws to target Italian and Irish immigrants deemed undesirable. Once that history entered the ruling, the debate changed forever. This wasn't just about modern policy anymore. It was about exposing the origins of a system built on discrimination. And once that truth was on the record, there was no putting it back. High-profile cases followed. New York's concealed carry law was overturned. Lawsuits exploded across the country. Permitless carry became the center of national debate. Supporters argued it restored equal access to self-defense. Critics warned of chaos. But then something unexpected happened. Federal officials stepped in, not to defend the licensing bureaucracy, but to dismantle it. They made a statement that stunned both sides. A constitutional right does not require permission. That single sentence flipped the entire conversation. You don't apply for a license to speak freely. You don't pay fees to practice religion. You don't wait for approval to invoke the Fourth Amendment. So why was the Second Amendment treated differently? That argument crushed decades of assumptions. And then came the data. States that already eliminated licensing didn't see crime explode. In many cases, violent crime dropped. That evidence couldn't be ignored. The licensing system wasn't built on safety or history. It was built on habit, power, and revenue. People who can legally possess firearms no longer need permission to carry them. But freedom comes with responsibility. Training matters. Knowledge matters. Criminals, not lawful gun owners, are responsible for violence. And yet, even as this ruling reshaped the legal legal landscape, something else was happening quietly in the background. Something far more dangerous. Here's where most people get it wrong. They hear licenses are unconstitutional and feel relieved. Like the fight is over. It isn't. States like New York, California, and New Jersey have been planning for this moment for years. They're not retreating. They're adapting. If they can't call it a license, they'll call it something else. New York is preparing character evaluations, social media reviews, family interviews, medical disclosures. California wants mandatory safety certifications. Same costs, same delays, same denials. New Jersey is considering ammunition approval systems. Illinois is floating mandatory insurance. Massachusetts is designing training bottlenecks so restrictive they function like bans. The name changes. The control doesn't. This is compliance theater. On paper, they obey the ruling. In practice, nothing changes. The Supreme Court can knock down the structure, but it can't stop states from rebuilding it overnight under a different label. That fight falls to citizens and legal organizations, and it takes years. The real danger doesn't arrive when the ruling is announced. It arrives in the days after, when states quietly move, when new rules appear buried in unrelated bills, when people assume everything is settled and let their guard down. If you live in a constitutional carry state, you're in the strongest position. But even there, stay alert. If you live in a license-heavy state, this is where things get messy. Lawmakers aren't waiting. They're testing boundaries right now, seeing how much resistance they'll face, and they're perfectly willing to move fast and quiet to preserve control. This is the moment to pay attention. Miss one update, and you could find yourself in serious legal trouble without realizing it. I've watched these battles for years. The fastest way to lose your freedom is assuming someone else is protecting it. Make sure you subscribe to Weapons Law Advisor, and don't forget to like and comment on the video to help us reach our amazing milestone of 10,000 subscribers. Every single subscriber matters. Your support is what makes this journey possible.